Hello class, in this revision lecture, we'll be studying about internal aids to interpretation. This is an important topic for your syllabus and I have already taught this topic and given all case laws, so you people can easily revise from my notes, PPT, assignment and this lecture video as well. And all those people who are studying it for the first time, it's very important for them because they can study it from here. You can also study from your sources, and if you have any doubt anywhere from your source or either from my source, you can get back to me. So let us start. Internal aids to interpretation. First, we know the meaning of interpretation. We need to derive the meaning of two words, internal and aid. Aid means help. Now, internal help means any help which is coming from within the statute. When you interpret a statute, we need to use certain kinds of help. We need to take certain kinds of help while deriving a meaning of a word or a provision of a statute or a phrase of a statute which is ambiguous. Interpretation क्यों करते हैं? जब कोई word, phrase या statute का कोई section ambiguous हो या दो meaning दे रहा हो या confusing हो या absurd हो, कोई meaning ही नहीं दे रहा हो, तो हम judges को interpretation करने की ज़रूरत होती है, meaning derive करने की ज़रूरत होती है. अब meaning derive करेंगे तो फिर help भी लेनी पड़ेगी. तो दो तरीके की help होती है, internal aid, external aid. Now, internal aid is something in where we take the help from within the statute. जब हम जो स्टैट्यूट एम्बिगुअस है या एब्सर्ड है या दो मीनिंग दे रहा है कोई वर्ड फ्रेज या प्रोविजन किसी स्टैट्यूट का या कंफ्यूजिंग है, उसी स्टैट्यूट से हेल्प लेके वो एम्बिगुइटी हटाते हैं, कंफ्यूजन हटाते हैं, एब्सर्डिटी हटाते हैं, तो उसे हम कहते हैं इंटरनल एड. और अगर स्टैट्यूट के बाहर से हेल्प लेते हैं तो उसे हम कहते हैं एक्सटर्नल एड टू इंटरप्रिटेशन. सो हियर वी विल बी स्टडिंग all those sources which are from within the statute and are helping in removing the ambiguity. So let us start. Various types of internal aids to interpretation. The first internal aid to interpretation is short title. Short title is the name of the act, like Indian Penal Code, Indian Evidence Act, Indian Contract Act. All these are the names of the act. They are telling what are we going to study in the act. Like if it is Indian Penal Code, then we are going to study about the penal liability. If it is contract, we'll be studying about contractual liability. If it is evidence, we'll be studying about how we can deal with evidence. Now, next is long title. A statute is headed by a long title whose purpose is to give a general description and the about the object of the act. That is statute. Next in internal aid is preamble. A preamble to the act contains the aims and objective sought to be achieved and is therefore part of the act. It is a key to unblock the mind of the lawmakers. Preamble tells the aims and objective of the act. So yes, if you are confused about certain phrase or word of the statute, you can go through the preamble and get the aim of the statute. Like if we are confused about the secularity point, then we can go through the preamble of the constitution and we can see that yes, secularity is the essence of our constitution. Marginal notes are those notes which are inserted at the side of the section in the act and express the effect of the section. They are also known as side notes. So they are important for interpretation of. Now next is headings. In all modern statutes, generally headings are attached to almost each section, just preceding the provision. For example, the heading of section 437 of the CRPC is when bail may be taken in case of non-bailable offence. Now, all these types of heading tells you what you are going to study in the heading. So they are important. They tell you the object of this particular section. Now headings are of two types, which are one which is prefixed to a section and the other which are prefixed to a group of sections. Sometimes you see that one heading is there just to tell about one section, but sometimes you see that there are headings which tell about groups of section or group of articles, like right of religion, right to faith and religion. There are many articles in there in that. Right, minority rights. There are many articles. So there are headings which tell about group of articles or section, and there are also headings which tell about that particular section also. Like here, the section which I have quoted, section 437. Now, exception and saving clause. Exception are generally added to an enactment with the purpose of exempting something which would otherwise fall within the ambit of the main provision. And saving clause are generally appended in case of repeal and reenactment of a statute. By this, the right already created under repealed act are not disturbed, nor new rights are created by it. A saving clause is normally inserted in the repealing statute. In case of a clash between the main part of the statute and the saving clause has to be rejected. I hope this is clear to you. Now, next is schedules. Schedules attached to an act generally deals with as to how claims and rights under the act are to be asserted, or as to how powers conferred under the act are to be exercised. The schedule are appended towards the end of the enactment. They tell you a elaborate discussion about the act and how all the rights and basically they tell you the whole uh, procedure related to the rights and liabilities which we have discussed throughout in the act, how it is to be asserted, and all the things which we couldn't write in the act are attached in the schedule. They give basically the full information. Next is punctuation. Punctuation marks are like all the comma full stop marks. In ancient times, statutes were passed without punctuation, and naturally, therefore, the courts were not concerned with looking at punctuation. But in modern times, it is very important. Therefore, when a matter comes before the court for interpretation, the court first looks at the punctuation marks, and if feels that if there is no ambiguity while interpreting the punctuated provision, they shall so interpret it. However, while interpreting the provision, if in the punctuated form, if the court feels repugnancy or ambiguity, the court shall read the whole provision without any punctuation, and if the meaning is clear, while so interpret it without attaching any importance whatsoever to the punctuation. If the punctuation are creating ambiguity, the court would remove it. If it is not, the court would read along with it. So it is also very important. I hope the internal aids are clear to you. If you find any difficulty, you can easily ask me. And the next internal aid is explanation. Explanation are inserted with the purpose of explaining the meaning of a particular provision and to remove doubts which might creep up if the explanation have not been inserted. So obviously they are explaining anything which is related to that particular section. So they can be used as an internal aid. Next is definition or interpretational clause. Definition clause or interpretational clause is always given in the beginning of the section statute, so that all the terms which are important in the statutes and are all repeated in the statute have been explained in the particular sense related to that statute at the beginning of the statute itself in some section 1, 2, 3, any section, and then you need to like section 3 or 4 of Indian Evidence Act also, and then that word would be interpreted in that particular sense only in which the explanation or definitional clauses or interpretational clauses explaining that section. And the last one is proviso. Proviso is the exception added to a statute to accept something from an enacting clause or to limit its applicability, which we have already discussed in the exceptional clause. That is same. I hope it is clear to you. If you don't understand anything, you can kindly get back to me. Thank you, class.